Hey guys, so McNallyOfficial has made yet another YouTube video. And in this video, he slaps a proven lock and it just kind of breaks down. So, not going to play his video, but it is a YouTube short. Probably only takes half a minute for him to disc and assemble what should be a very expensive lock and give him a view. That's his channel. Now, I do want to point out a few things about the lawsuit in the affidavit. Apparently, there are very nasty words being used. I'm going to read you the affidavit, but this is the newest video, which was uploaded 4 days ago as of the recording of this video. So, proven heavy duty padlock slapped open, and it is exactly what it sounds like. So, McNally, upon not stopping, right, they filed for the emergency injunction, which was denied, has continued to make more videos about the proven lock system, which have been quite embarrassing. And the way he's doing, I don't know, I'm not a lock picker myself, but it seems like it's very easy. You just kind of slap it around and then it just falls apart. It's like, what was the point of that? I can read you some of the funny comments here. Calling out and then suing McNally has to be the award for the dumbest move by a company. I have been in PR marketing industry over 20 years, and this has been one of the best self-destructions by company I witnessed. Proven Industries, he used specialty tools that anyone can buy at a hardware store. Master Lock gets a restful night's sleep tonight. Get bored with raking the pins in half for a second, we've moved on to spanking the locks into submission. Quick reminder, these proven lock guys started harassing the guy's wife and even somehow found her number to harass her. No words, no flair, just pure spite, and I'm loving it. About time someone educate them on anti-slap. I think this padlock has the highest HP on all the padlocks in the channel. It endured 8 slaps. Said it before, but if there are any screws, nuts, or bolts on the outside, it is not a lock, it is just art. Valid, you tampered with it, proven. The fact that he paused after one hit means he has on previous attempts seen it open after one hit. This is the Proven Industries Heavy Duty Padlock. It can be opened with a Proven Industries Heavy Duty Padlock. That's kind of funny, actually. All right, so basically, I don't know like what is going on with these things. In my opinion, I'm as a non-expert in lockpicking, it just looks like too simple. It's almost like unbelievably easy to open these things, and for them to cost like over $100. I mean, what are you protecting that? Maybe some Pokemon cards. But I'm going to go over the legal stuff, and the legal stuff is going to really have you scratching your head because it had me scratching my head as to why this company would continue to put itself in a very unfavorable position. Some of the allegations they've made, so in the affidavit, this was filed June 20th, motion to file under sealed. So we actually had looked at the motion to seal, and they were saying, employees and harassment. So they only had 2 attachments here. Ronald Lee, who is the president of Proven Industries, and Derek Faley, who I believe is the lawyer. These are very interesting. Derek Faley, he is the attorney and lead counsel. He's eating well tonight, guys. You don't need to worry about our good friend Derek. He's making good money from Proven Industries. Back to kind of this lawsuit. It is just a classic example of what not to do. So sometimes lawyers have to be advisors, and beyond the legal scope, the lawyer just needs to say, hey, we need to stop this lawsuit. This is not going to go well for us. We're getting clowned on by everyone online, and this guy is continuing. So remember, the lawyer suggested and wrote a emergency injunction, which had 30 attachments to it, each attachment being quite long, and it was denied. So the emergency injunction, and that was complete waste of time. In my opinion, if you have a very strong case, you don't need 30 exhibits and affidavits. So here's the declaration of Ronald James Lee in support of plaintiff's motion to seal. Now they've been crushed so much in the PR sense that they have basically cried uncle, and they do not want anyone or any witnesses, affidavits, any of that stuff to come out. No names, because these people do not want to be associated. I am the president of Proven Industries Inc., Proven, the plaintiff in the matter. After plaintiff filed its complaint, my family, loved ones, and multiple Proven employees were subject to persistent and targeted harassment from defendants' followers. On or around June 3rd, after plaintiff filed plaintiff's emergency motion for preliminary injunction, my girlfriend, who lives with me at my home address, received a letter. The letter was addressed not to me, but to my girlfriend. She is not listed on the title or deed of my property. There is no publicly available information indicating that she resides with me. So, what does this letter say? Is this a real letter? You know, the letter, unfortunately, we get the attorney's version of what they've stalled in the letter. People write nasty letters all the time online. I don't know why this is such a big deal for them, but okay. Stated that people in the lock sports community were looking into my background. What is very concerning about this letter is that it is not publicly known my girlfriend lives with me, which means that McNally's followers are willing to search for, find, and use non-public information in an attempt to contact my loved ones to potentially affect them. The June 3rd letter was mailed with an individual using the name Jeff Hall, with a return address in St. Paul, Minnesota. It's speculated that my partner might be unaware of my past, concluded with a warning to her to be careful. The sender also stated that a copy of the letter would be sent to her workplace just in case Ron intercepts this letter. Additionally, my girlfriend also received a second similar letter at her workplace. Both of these letters were very disturbing and concerning because they demonstrate the individual influence by defendants' content. I've never seen McNally tell his subscribers to do this, and I doubt that he does. He's just picking your lock, dude. One of McNally's followers posted my personal phone number in the comment section of one of the defendant's social media platforms. I have since received numerous harassing and threatening messages at all hours of the day and night. The messages include profanity, racial slurs, and explicit threats. Is this a minority? Is this guy white, or is he like Asian? My son has received highly disturbing text messages, including threats involving racial violence and derogatory slurs. Actually, you know what? We gotta check up. So, what is his name? His name is Ronald Lee. Is Ronald Lee Asian? Why are they using racial slurs on him? I do not know. I think they're white. Yeah, I think they're white. I'm looking at pictures. So they're using racial slurs against him. Okay. The video reused content and prompted widespread negative review of Easy Home's lock. So he's saying that this has happened to someone else before, and McNally's followers have attacked the Easy Home people. Manhunt for Ronald Lee. This is the same guy. Like, it's a very common name. I believe if the court's forthcoming order and hearing transcript on the emergency motion for preliminary injunction are made public, the documents filed by the parties related to emergency motion for preliminary injunction remain public. The facts contained therein will embolden defendants' followers to accelerate or increase McNally's followers' harassment efforts, and the materials may become the next source of targeted attacks. Based on these experiences, I believe that sealing the documents related to plaintiff's emergency motion for preliminary injunction. I can pull this stuff up right now. Just because you filed it, as I later found out with Logan Paul, doesn't mean they actually delete it. So court reporter will just have it for you. Yada, yada, yada. And then we get to the interesting part. The lawyer is definitely making a shit ton of money from this, man. Because the lawyer is the witness to this letter. I've never seen anything quite like this, but hey, man, good for the lawyer, right? He's got his billable hours. Declaration of Derek Fowry, he's the lawyer, in support of plaintiff's motion to seal under local rule 1.11. I, Derek Farley, declare as follows. I am 18 years of age and reside in the Middle District of Florida. So when your witness is your lawyer, and that's it, shouldn't the wife be the witness? I'm not sure what's happening. I think the wife received the letter, right? I'm in the attorney licensed to practice law in the state of Florida and serve as lead counsel to Plaintiff Proven Industries. In preparation for the preliminary injunction hearing, I contacted multiple individuals with relevant expertise to provide declarations or testimony in support. These individuals were selected based on their professional background and experience in lock and security. However, after disclosing the situation to a third party associated with the witness's business, the witness later informed plaintiff's counsel that witness will not participate in any way due to fear of professional and personal retaliation. Specifically, the witness in the witness's own written words expressed concern about blowback. So, like, instead of having the witness say this, it's the lawyer interviewing the witness. It's a secondary source. A second witness, Anthony Bofingo, who eventually signed and submitted a declaration, also expressed concerns about the potential for backlash by McNally's social media followers and viewers. In an email sent to my office, Mr. Bofingo asked, "Is this going to be public? My concern is there might be some backlash from the other side towards my company. Based on my review of communications between my law firm and both individuals, I believe their concerns were genuine and materially affected their willingness to participate in the proceedings. One witness entirely withdrew, another proceeded only after acknowledging the risk and hesitating due to concerns about the effect on testimony could have on his business. These interactions demonstrate the conduct of individuals influenced by defendants' online posts have already chilled the participation of at least one non-party witness in this case. Additionally, after plaintiff filed plaintiff's motion for emergency, here's Mr. Lee, here's a letter. I read that letter. One of the things that is concerning about this letter to Mr. Lee's girlfriend is that online harassment from McNally's social media followers have now moved to the physical world, and some of the messages Mr. Lee's family. What did they expect? Like, I don't understand what they expected everyone to give them flowers and cheer them on as they sued a guy who picked your lock. I mean, I don't know what their expectations was, but okay, so this is interesting. I blank a blanking not blank, and I want to blank your friends, and I would kill your blank child. Indeed, at least one of McNally's social media or viewers spent the time to investigate Mr. Lee and his girlfriend, determine where Mr. Lee's girlfriend lived, even though it's not public information, For these reasons, I believe the court's order on public disclosure would increase the likelihood of retaliation to proven and the witnesses. And so they don't want to make it public, but by definition, these things are public. So I don't know what they're complaining about. The lawyer should have explained to them, hey, in a lawsuit, there may be things that are private that are made public that you may not want, and there may be backlash. That's how lawsuits go, man. If you really want to go into it, you can look at big drug companies versus whistleblowers. I mean, Theranos is a very good example. The whistleblower on Theranos, right? I mean, his granddad sat him down and said, give him a spanking, right? And he was right all along. He was right that Theranos was a scam. And actually was putting people's livelihoods in danger, and he stood up, and his own grandfather invested in Elizabeth Holmes and gave him a spanking at dinner time to tell him, hey, don't mess with Elizabeth Holmes. Anyway, yeah, pretty interesting stuff, but it's good to see McNally continuing to spank the proven industry's locks. Let me know what you guys think in the comments below. Bye, guys.